Greetings to all learners. Myself Sharda Devre, Associate Professor, Government College of Pharmacy, Amravati, welcomes you to the Lecture 26 IPR and Indian Government Initiatives, that is a TKDL and TKRC, under the Week 6 IPR and Protection of Traditional Plant Drugs Knowledge. Intellectual property rights are the exclusive rights, like the land, shop, jewelry, or cash, which are the movable or immovable properties, and that cannot be utilized without the permission of the owner. Similarly, there are also certain intellectual properties like the patents, trademarks, trade secrets, copyrights, geographical indications, utility models or design models, and plant breeding rights. And these rights also cannot be utilized by any other person without the permission of the owner. These rights of intellectuals are given within the limits of the law, because the social benefits as well as the owner's investment on such a research should be compensated well. Now let's learn about the history, that why there was a need for a system for the protection of the intellectual properties. In 1873 in Vienna, there was the International Exhibition of Invention, and most of the people were afraid to showcase their ideas because that would be stolen and exploited commercially in other countries. So in 1883, the Paris Convention has formed, which was related for the protection of the industrial property, and in 1886 the copyright entered in the international arena with the Berne Convention, and these both Paris Convention and Berne Convention together in 1893 formed the United International Bureau for the Protection of Intellectual Property. It is French acronym known as a BURPI. Based on Berne, Switzerland, with a staff of 7, the BURPI was the predecessor of what is totally today is known as the World Intellectual Property Organization, or WIPO, that was established in 1967. WIPO is specialized in agency of the United Nations and which administer the matters related to the IP for its member states. Then it has been found that there is a need for the harmonization as well as the dispute handling is a must, or it should be handled systematically. So for that, the World Trade Organization and then the trade related aspects of the intellectual property rights, that is a TRIPS agreement, that evolved, and that came into force in 1995. So altogether these are responsible for the various IP matters throughout the world. India has also took the very necessary initiatives time to time related for the intellectual property rights. The first initiative, that is a Copyrights Act in 1957, Patents Act in 1970, Trademarks Act in 1999, Geographical Indication of Goods Act in 1999, and Designs Act in 2000. Recently, India has also announced the first national IPR policy in 2016, which falls under the Department for Promotion of Industry and Internal Trade, that is a DPIIT, and this cell promotes the IP awareness, its commercialization, and its enforcement. Also, India has took the very positive steps related to the technology enhancement, like the e-filing of the applications, then delivering the certificates of grant and registration of the patents, trademark, designs in a digital formats, then video conferencing for hearing of the IP applications, then expedited examinations procedures for the patents or other applications, and then the spreading of the awareness related to the IP issues. DPIIT, in association with the Federation of Indian Chambers of Commerce and Industry, launched the first toolkit to handle the IP crimes, that is a Maharashtra IP crime unit, which handles the digital piracy related matters. And thus this is the first type of the toolkit in India, and Maharashtra is the first state to handle such a type of the digital IP piracy related matters. Now let's learn the very important and popular intellectual property, that is a patent. Patent is related to the invention. It is not the discovery or innovation, because discovery and innovation are very common for the Fosita, that is a person having ordinary skills in the art, but invention requires the greater intellectual skills. These are the exclusive rights for making, using, selling, importing the patented product or process, and these rights are given for the limited period, that is for 20 years, and after the exchange of the full disclosure. The invention must be novel, non-obvious, and having the utility. And why such rights are given? So that the person should get the award for its own creativity, and to promote the creativity of such a people, as well as to have the technological and economical advances of that country. Such a rights are given. There are three different types of the patents: utility patent, design patents, and plant patents. What can be patented? So that anything which is novel, non-obvious, and having the utility can be patented. Any technical solution of a problem in any field of a human activity which is new, involves an inventive step, and industrial applicable shall be patentable. Now when prior art is the case, means if it is available in a traditional text, or it is commonly available in the day-to-day life of the people, then such a type of the uh, things, products, or processes cannot be patented. Let's learn more in detail that what cannot be patented as per Indian Patents Act under the section 3. That is section 3A, frivolous invention; section 3B, that is inventions which are contrary to the law or mortality or injurious to the public health; then mere discovery of scientific principles or abstract theory; then mere discovery of a new form of a known substance; then for this section 3D, the Glivec case of the Novartis company is very popular in India. Then section 3, that is a mere admixture; section 3F, mere arrangement of the known devices; section 3H, that is a method of agriculture or horticulture, cannot be patented; section 3I, that is any process of the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human being, cannot be patented. It is even for the animals the same case is applicable. Section 3J, it is for the plants and animals whole or any part along with the microorganisms, cannot be patented. Section 3K, that is a mathematical or business method or computer program, cannot be patented. Section 3L, a literally dramatic, musical, or artistic work on any other aesthetic creation, cannot be patented because it comes under the copyright. Then section 3M, which is related to the mental act or method of playing game, cannot be patented. Section 3N, a presentation of informations like in the form of PowerPoint or in the form of books, cannot be patented. Topography of integrated circuits is not patentable. Section 3P, which is related to the traditional knowledge inventions, that cannot be patented, and the atomic energy related inventions cannot be patented. Next intellectual property is the industrial design, which is eye-appealing design of useful articles, either ornamental or aesthetic, despite of distinctive or functional necessity. So here you can see the different designs. They are not giving any type of the very functional creativity, but they are looking appealing, or they are looking aesthetic, and hence such a designs are having the good commercial value. This need the great potential of the intellectual, hence these are considered under the intellectual property rights. The intellectual property rights for the industrial designs are initially given for the 10 years, and further it can be extended for the 5 years. Next intellectual property right, it is a copyright. This is very common in the education system, and this copyright is legal rights granted to the work of the authorship or creatorships for the literature, drama, music, art, image, graphic designs, sculptures, architectures, choreography, motion picture, sound recordings, and these copyrights are given for the 60 years of a time durations, while in case of the literally dramatic, musical, and artistic work, it is for the 60 year from the year of following the death of the author, also means up to the age of the author, and further after the death, then up to the 60 years. And the copyrights are divided into the economic rights, moral rights, and related rights. Related rights involves the performance rights, then phonograms, producer rights, and broadcasters rights. Next important intellectual property, it is a trademark, which is a distinctive and deceptive sign to distinguish goods and services. It can be word, phrase, symbol, design, or combination of these things. And here you can see that this type of the symbols or words or different colors combinations are there. These trademarks can be conventional trademarks or non-conventional trademarks. Then collective or certification trademarks. Again, as per market, there are the 5 different types of trademarks, that is a generic marks, descriptive marks, suggestive marks, arbitrary marks, fanciful marks, and these are segregated into the 45 different classes as per the NICE classification. The trademark is valid for the period of 10 years, and after which it needs to be renewed for using it again. The symbols are here which are very important. The TM for the unregistered trademark, SM for the unregistered service mark, and R is for the registered trademark, either for the service or for the product or goods. Next intellectual property, it is a trade secret. Trade secret must be not generally known to the public. And why this is so? Because such a secret is responsible for the certain type of the economic benefits, and reasonable efforts need to be maintained by the manufacturer or owner to maintain its secrecy. Trade secrets are not protected by the law in the same manner as of the trademarks or patents or like other intellectual properties, but instead the trade secrets are protected under the state laws, and it not involve any type of the registration. Here the one example of the composition or flavor of the Coca-Cola is mentioned, which is a great secret till date. The next intellectual property, it is a geographical indication. Nowadays this is very popular, that is a GI tag goods, and it is indication and appellation of the origin of the goods, origin of the quality, and this is due to the skills that are developed by the people in that area or the various atmospheric conditions. Now for example, made in India or champagne or what, these are the photographs that are shown of the various textile materials or fruits or teas that are from that particular geographical region. Bioprospecting and biopiracy are two important terminologies from the point of view of India, because India is a great biodiversity, and bioprospecting, it is the systematic and organized search for the useful products that are derived from the nature, especially the plants, microorganisms, and animals, and then further it can be used for the commercialization and overall benefits of the society. While biopiracy is actually the unauthorized utilization of biological resources, especially with the traditional knowledge, and then its commercialization without any type of the compensation. Indian traditional knowledge is playing the very important role for the human health care, and it is having the history, culture, and tradition. There are so many Ayurveda, Unani, Siddha practitioners, as well as the herbal healers, and the biodiversity of India is having more than 7,000 plant species, and these are also contributing to the modern medicines. Biopiracy is the situation where indigenous knowledge, traditional knowledge is commercialized by the scientists or the uh, researchers or industry people without the permission of these traditional knowledge holders, without giving any compensation or recognition to these peoples. And when this particular terminology came into force, that is after the landmark case of the turmeric and neem, and after that so many cases there are. But in case of the turmeric, the US patent given to the healing properties of turmeric, and which is known for centuries to the Indians. It is very commonly practiced by Indians to use of the use of the turmeric for the wound healing. And then Indian Research Organization provided the various proofs, and then this patent was overturned in 1997. This was the first case of successfully reversing the biopiracy patent. While before that, in 1993, the PJ Margo Private Limited began producing and marketing the neem biopesticide, and on the grounds that the product and process was not novel, Indians has been using the neem products in the same fashion for the centuries. And the European Patent Office revoked the patent in Europe, but the US patent remains valid, because in the US the use of invention outside the US does not destroy the novelty, as well as there were some of the claims of that patent that were novel and that were not mentioned in any of the traditional text or document of the India. Due to increase in the cases of biopiracy and the time, effort and money spent on the revocation of the various patents based on the traditional knowledge, the Indian government has took the initiative of the Traditional Knowledge Digital Library in collaboration with the CSIR and Ministry of Ayush to prevent the exploitation and to protect the Indian traditional knowledge. Because 70% of the population of India is depending upon this traditional knowledge for their basic healthcare needs. And here with the screenshot of the TKDL website, you can see that the one means different tabs are given, that is about TKDL, biopiracy, source of information, TKDL outcomes, major milestones. So thus this particular traditional digital library has conceptualized to overcoming the language and format barrier by systematically and scientifically converting and structuring the available contents of ancient text, traditional knowledge of the Ayurveda, Siddha, Unani, Soa, Rigpa, as well as the yoga practices into the 5 international languages, that is English, Japanese, French, German and Spanish. Traditional knowledge resource classification, which is called as a TKRC, is the system of classification based on the structure of international patent classification, that is IPC, and this has been developed for the Indian systems of medicine, that is Ayurveda, Unani, Siddha and Yoga. And this type of the TKRC documentation has gained the international recognition. This is linked to the various patent classification systems, and hence it is utilized to prevent the grant of wrong patents for the non-original discoveries relating to the traditional knowledge systems. In the structure of TKRC, the TKRC is divided into the following sections: A for Ayurveda, B for Unani, C for Siddha and Y for Yoga. And further then there are sub classes, like the one is for pharmaceutical preparations, that is Kalpana, 2 is for personal hygiene preparations, 3 is for dietary food stuff or beverages, and 4 is for the biocides fumigatives, that is a Dhupana and the Krimigna. Then next sub classifications are there, that is a 01A based on plants, 01B based on animals, 01C based on minerals. So suppose there is a A01A, then it represents the pharmaceutical preparation based on the plants. So this type of the classification system has made the lot contribution not only in India but throughout the world, to prevent the grant of the wrong patents and to prevent the biopiracy. In this lecture 26, we have learned about the intellectual property rights, then Indian government initiatives to introduce the various acts related to these intellectual property rights. Then we have learned the biopiracy, bioprospecting, traditional knowledge importance, and the Indian government initiatives, that is a traditional knowledge digital library, TKDL, and traditional knowledge resource classification, that is a TKRC. Hope the learners will use these both initiatives of the Indian government to understand the various biopiracy case, and whenever they will involved in the IPR protection, they will also go through such a type of the systems. Thank you.